right, good evening, ladies and gentlemen. It's time to call to order the special meeting of the Development Commission for the discussion of the public hearings on Issaquah Highlands Retail, Issaquah Highlands Medical Office Administrative Site Development Permit, and Issaquah Highlands Self-Storage Administrative Site Development Permit. Before we get started, there are a couple of administrative issues that we need to take care of, including approval of some minutes from April 30th and May 7th. So, commissioners?
Mr. Chair, I move we approve the minutes of the April 30th, 2019 meeting.
Second.
Is there any discussion? All those in favor of approving the minutes, say aye.
Aye.
Opposed? Okay, motion passes. How about the minutes of May 7th?
Mr. Chair, I move that we approve the meeting minutes from the May 7th meeting.
Second.
Well, good. Any discussion? All those in favor of approving the minutes of May 7th, please say aye.
Aye.
Opposed? Motion carries. Without further ado, I think, Mr. Snyder, we are still in the notion of cross-examination of Miss Lucy Sloman.
Ms. Sloman, could you turn to S-113, please, which is the letter you wrote to my client?
Could you speak up? I'm sorry, I couldn't hear what you were saying.
I apologize. I'd like to begin more or less where we left off with Exhibit 113, the letter that you wrote on April 15th informing my client that they're not vested to process.
Is that, what, could you give me the number again now that I have the notebook? 113?
Yes, S-113.
133? Yeah.
S113?
Could I interject and make sure that we still have you under oath? Is there, we want to do that?
I am still under oath.
Could you, per the chairman's request, could you please acknowledge that you continue to be under oath from your prior proceedings?
I do.
Thank you.
Okay.
And I'd like you to turn to the last page of your letter, please. And I want to ask you about the language that you put in bold, telling my client that your letter is not an appealable decision. You know my client believes they are vested to process under the development agreement, do you not?
I know that that's what they're ascertaining, yes.
Okay, and so why did you decide not to let them appeal your decision to the contrary until after you had put them through the process that they believed to be unlawful?
I believe that this note is consistent with the hearing examiner's decision on previous requests by your client that certain letters and communications are not appealable.
Well, the hearing examiner, in my recollection, decided that your department had not made an appealable decision. And are you saying that you didn't have any choice and that you've to make it appealable or not?
I think we were just trying to be clear about how we viewed this communication.
Okay, well, by not making it an appealable decision, you agree, do you not, that my client has to go through the process in the replacement regulations before it can make its arguments why the process is illegal, just like we've been doing for the last 9 months here, correct?
That would be the conclusion, yes.
I'm sorry?
That would be the conclusion, yes.
Okay. And so have you done anything since the last hearing to move forward with the processing of my client's plat application?
Yes.
What have you done?
I've been working on trying to find models for community conferences to discuss how that process would apply in this circumstance, since we're doing it under the the replacement regulations. This is somewhat new.
Have you written the staff report?
No, I've been finding the correct format for the staff report.
Okay, and have you made a decision as to what my client is and is not vested to pursuant to its plat application?
I would cover that in the staff report.
I'm sorry?
I would cover that in the staff report.
Well, my question was, have you made a decision by tonight about the application submitted 21 months ago about what is vested and what is not?
I'm unclear why I'm being asked to explain that for a plat related to these permits.
Well, either you or Mr. Niven made that objection months ago, and I responded to it, and I think you need to answer the question, Ms. Sloman. How can you process, and let me ask a different question, how can you process a plat application if you haven't decided what my client is vested to?
Well, my understanding is that you are vested to the, I thought the April 4th, 2018 letter identified that. My understanding is that you are vested to those things that state law allows you to vest to for a preliminary plat, which has to do with what is shown in your original plat submittal.
Well, I'm asking you what that means in terms of my client's plat application. What my client submitted, we've already heard testimony that my client's plat application reflects the footprints of the SDP applications that are before this hearing. Are you not, have you made a decision about whether those buildings are vested or not?
I think we've spoken to that previously, that that was not in the original submittal.
Okay, so Ms. Sloman, why don't we turn for a moment to the chart that you submitted and prepared last time, Exhibit C59. Can you pull that up, please?
Okay.
So you testified a couple of times at the last hearing that you believe this chart was more accurate than the materials that Ms. Heim prepared and submitted.
In some cases, yes.
How did you decide what to include and what to not include on your Exhibit C59 that you prepared for this hearing?
So the permits that I included were the ones that I was aware that your client had spoken to as comparable or not comparable permits to their permits.
Well, I'm not, well, one of the permits that you didn't include in here, correct me if I'm wrong, is the plat application that we've submitted by Polygon that we've had testimony about at this hearing that you approved after you had approved the SDPs or the SDP on one of the lots in that short plat, correct?
I did not include the short plat. I was focused on the larger land use permits and not all the short plats and lot line adjustments that we had received. No, we spoke about that separately.
For shelters applications, how did you decide which meetings with the city to include and which not to include?
I tried to include the ones that I found in my notes and my calendar.
Well, there are a number of meetings that you attended with Shelter about its applications that are not on here, isn't that correct?
Not that I'm aware of. I tried to be complete in the meetings that I identified.
Okay, would you pull up Exhibit C44, please, which are the minutes that Ms. Heim prepared of her meetings with you that the city offered into evidence?
Okay.
And would you turn to the notes for 5/18/2016 and see whether they reflect the meeting with Shelter that you attended?
I'm sorry, this is in C44. The last item that's in here is 2/15/18. I thought you...
I'm asking about 16, May 18, 2016.
Oh, 16. Okay.
Isn't that a meeting that you attended, according to Ms. Heim's notes?
Yes, I did not include meetings, as I testified last time, I did not include meetings that I thought were related to the development agreement, but rather processing of permit applications.
But were all of the meetings with, at least by 2016, with Shelter about the applications that it intended to submit and wanted to submit?
My memory was that did not begin until sometime in 2017.
Well, let's look at your Exhibit C59, Ms. Heim. You've included a meeting from June of 2016 under the heading of General Planning, correct?
Yes.
Well, didn't you just describe the meeting that in May that you didn't include? Wouldn't that fit under the column of General Planning, under your description of it?
As I said, I haven't read through these minutes, so I don't specifically remember that meeting. What I had referenced was at the time that not when we were discussing a new development agreement or an extension of the development agreement, but specific pieces related to how the land might be configured or the specific permits that they were preparing to submit.
And I think my specific question, Ms. Sloman, was wouldn't that meeting, as you described it, fit under the heading of a general planning meeting?
I have not read these minutes, so I'm not able to respond. If you would like to give me a few minutes, I will try and look through them.
Well, why don't we turn to the minutes for July 6, 2016, and see if that's another meeting that you attended that isn't on your chart.
So if you would like me to respond about these, I would need to have an opportunity to review the meeting minutes. I tried to parse them based on which ones seem to be development agreement related versus permit related, but I have not reviewed these meeting minutes, so these meeting notes, I am not able to respond instantaneously.
All I'm asking you is whether that describes the meeting that you were at, Ms. Sloman, on July 6th of 2016. Can you confirm that to be the case?
That these meeting minutes, the notes show that I was there?
Yes.
Yes, these meeting notes show that I was there.
Okay, and how about the meeting on September 21st of 2016? Is that another meeting that you attended that isn't on Exhibit C59?
I am listed as an attendee in the notes, yes.
Okay, so again, you included under the general planning column for my client a meeting in May of, May of 2016. Is your explanation for not including these others then that you didn't remember them?
No, I categorize them differently.
Well, again, that brings me back to the question, even under the characterization that you gave us, they appear to fit under the general planning column.
That's your determination, having had a chance to review these meeting notes. I have not had a chance to review these meeting notes.
Well, Ms. Sloman, you testified that you didn't include things in this chart that were about specific applications. If your characterization is these meetings weren't about specific applications, then how can they not have been about general planning for shelters property?
What I meant by general planning was looking at configurations for all of the property or specific plans for individual pieces of property. I don't know, based on being given dates that I attended meetings, whether I made an error or whether you were categorizing them different than I intended.
Okay, well, can we agree that we've already had testimony in this record about meetings that you had with my client that are not on this chart?
I attended meetings that are not on this chart. I would assume that that is because I did not think that they were consistent with the intent of the chart when I created it.
Well, I thought the intent of the chart was to give us an accurate summary, more accurate than we had given, of your communications with my client about these applications.
Yes, about these and other applications, not about the development agreement.
Okay, I'm handing you what we marked as Exhibit S126. This is a new exhibit. Tell us what this is, please.
It looks like a meeting that I set up on September 7th, 2017, the subject of which is end of DAs and shelter holdings property.
Okay, this is a meeting you set up in September of 2017, and it's not on your chart either, correct?
I would not expect it to be, because when it says end of DAs, that is end of development agreements, and I am guessing that this meeting had to do with the replacement regulations, based on the subject that's identified.
Ms. Sloman, meeting is from September of 2017, September 7th. What state were the replacement regulations in at that point in time?
The replacement regulations were going through the Urban Village Development Commission and Planning Policy Commission.
Had the city released a draft of the replacement regulations?
Yes, I believe we did in mid-August.
Okay, and this is it, but your subject is a description of end of DAs and shelter holdings property, correct?
That is the subject, yes.
Okay, and you knew Shelter Holdings was submitting applications to vest to the development agreement, correct?
I don't know that I knew that. I knew that they were submitting applications at some point in the near future, yes, but
Ms. Sloman, are you trying to tell us that you believed in September of 2017 that Shelter was submitting applications for the replacement regulations that hadn't been adopted yet?
no.
So
May I finish? What I think again, I have no notes in front of me. I do not have my notes in front of me. Based on the title, I would assume that, like TriMet Properties at Talus, we were meeting with those applicants who had undeveloped property and had questions, concerns, and comments related to the replacement regulations and ideas about what uses, what development standards, and they were asking questions and discussing that with us, not necessarily any specifics about the properties.
Well, Ms. Sloman, didn't you just describe a meeting with TriMet?
We had meetings with TriMet, we had meetings with your client.
Okay, and I'm asking about this meeting. Do you have any memory of this meeting, other than what the title, the subject line of the email tells us?
No?
You put on exhibit Going back to Exhibit C59, Ms. Sloman, you put on here in the last column the end of the build-out period. Why did you include that?
I thought it might be a useful piece of information.
In what way?
Just marking different things that were taking place. And the end of the build-out period was one of the things that occurred, and it provides information about what was happening, the larger context.
And do you attach any legal significance to the end of the build-out period?
It is the city's contention that that is when the contract ended, and after that, circumstances changed.
I thought the city's contention was the contract ended on March 28th when the replacement regulations took effect.
Well, I think there are different, don't know what the right word is. There was a guarantee, a level of confidence or predictability through the end of the build-out period, and then a level of uncertainty between the end of the build-out period and when the replacement regulations were adopted.
And are you saying that this period has significance for the vesting issue that this hearing is about?
I believe so.
Did you hear Mr. Niven's testimony about that issue?
Yes?
Did Mr. Niven testify that it did not have significance for the vesting issue that this hearing is about?
I'm not sure that he said that it did not have significance.
Your chart indicates that by the time my client submitted its applications, you were fully staffed, correct?
We had the staff positions filled, yes.
Okay. And you said one of the themes when you introduced this chart was that one shouldn't wait to the last minute. Do you recall seeing that?
Yes.
So in looking at this chart, I see several applications by Polygon that were submitted well after hours and have been processed to approval. So is there a different last minute for Polygon than for Shelter?
So as we have discussed at length, Polygon's permits were linked to a development agreement that was executed with the city related to affordable housing and transfer of development rights.
Yes, and we've heard testimony, including testimony from Mr. Niven, that that development agreement does not refer to vesting. But I understand the city's position is that that development agreement that doesn't refer to vesting vests Polygon to the development agreement, but not my client. But nonetheless, what does that have to do with when it's too late to apply and when it isn't?
I'm sorry, I didn't follow that question.
What is the distinction that you drew between vesting pursuant to a development agreement that doesn't mention vesting and my client asserting it's vested to the development agreement? What does that distinction have to do with the fact that you processed Polygon's application submitted after hours to completion, and none of our applications are anywhere near completion?
I'm still having a hard time tracking your question. I believe the distinction that you're asking about is that the city identified that Polygon's permits were vested based on their development agreement. Your client's applications were not vested beyond the build-out period of the Issaquah Highlands development agreement.
And again, I fail to understand why the development agreement we're talking about has any effect on the processing speed. I'll make one more attempt, Ms. Sloman. I'll rephrase the question. Please explain, if you can, why the development agreement, one versus the other, has any effect on how quickly you process the applications.
So we would have to look at the applications individually. Your client's land use permits, the site development and administrative site development permits that we are reviewing now were determined to be complete in mid-March. And when we asked you to update them consistent with the development regulations, your client declined. And so that sent us into the process we are now in of trying to process them in a much bigger context.
Let's talk about the plat and compare the two plats, Ms. Sloman. The plat for Polygon, the single-family north plat, that vested to the development agreement that Shelter believes it's vested to, correct?
West Ridge North single family vested to the Issaquah Highlands development agreement, yes.
Okay. And it submitted 1 month before we did, correct? In July rather than on August 1st of 2017?
Yes,
And it was given final approval by the city council last summer, correct?
yes.
You shifted staff resources around to process Polygon's applications more quickly, didn't you?
No, I shifted staff resources around based on their experience and their workloads.
Yeah, I have two new exhibits I want to offer. This one first. These will be 127 and 128. Why don't you take a moment to look at this, please? Yeah, there's actually an attachment to that exhibit, which is not stable, but it should be included. So I'm bringing up the attachment. And while we're at it, let's pass out 128. So do you recognize these documents, Ms. Sloman?
Sort of. They're quite dense, so I haven't worked my way entirely through them. It seems like they are related.
Yes, and I'll represent to you, and you can confirm this, that 127 is an email exchange between you and Jean Lynn that includes much of the content in 128, which was an email that was sent to Mr. Abdelnauer at Polygon with the content that you and Ms. Lynn had worked out in 127. So if you can take a moment to confirm what I just represented, please.
Okay, I sort of have a grasp of them.
Isn't it fair that what these two documents demonstrate, Ms. Sloman, is that you shifted two planners, Valerie Porter and Dan Martinez, onto Polygon's projects so they could move along more quickly in response to complaints from Polygon?
No. We made the shift because the number of permits that Jean was assigned as our only senior planner was too much. And so we were trying, Jean and I were trying to go through her permits and identify which ones she would retain and which ones could conceivably be handed off to other planners.
And what you handed off to other planners were Polygon projects, correct?
And City Surf, she asked to retain your plat.
Okay, and City Surf is also on C-59, correct?
Yes.
And it was granted final approval in October of 2017,
Yes.
a month after this email to Polygon?
Approximately, it appears so.
Okay, why don't you read to us, please? Why don't we do it from S-128? I believe the same language is in both. It's towards the bottom of the first page of S-128, the paragraph entitled Staffing.
While we are currently fully staffed, several of us, including myself, are new and still in the process of ramping up to optimum service levels. As the anticipated workloads for all 5 projects exceed the capacity for any one planner, we are looking at bringing in 2 newer planners to assist, Valerie Porter and Dan Martinez, with Lucy and myself continuing to stay involved to provide guidance. Staffing for projects is identified in the project section below.
Okay, and so are these 5 Polygon projects you're talking about?
Well, we're writing to Polygon, so we're speaking of Polygon's projects.
Okay, and are all 5 of those projects on your Exhibit C-59?
Where is the list of projects? Oh, on pages 2 and 3?
No, I'm looking at your Exhibit C59, your chart.
Okay. So I'm sorry, now I'm looking at C59. Tell me which projects you're referring to?
Asking you whether the 5 polygon projects you referred to, or specifically Ms. Lynn referred to, are on your Exhibit C59.
Yes, it appears they are.
I only see 4 polygon projects that were still in process in September of 2017. Is there a 5th one on here?
I'm sorry, I don't understand the question. You asked me if the 5 permits that are shown, that are listed in Jean Lynn's email are on C59, and I said yes. And then you were asking if some of them, if one of them was still in process in September 2018? Was that the question?
No, I was in response to your testimony that all 5 projects polygons that she was referring to are on C59. I was saying I only see 4 polygon projects, and I was asking what the 5th one is.
So if I start on page 2 of Jean's list, South Townhomes construction permits, 109 townhouses. That is listed on C59 as Townhome South SDP 1600001. Single Family North plat listed in her email is listed as West Ridge Single Family North PP 171231000001 on C59.
Lucy, they're having a hard time hearing you.
I'm sorry?
They're having a hard time hearing you.
Oh, thank you. North Townhomes SDP, which is with 111 townhomes in S128, is, I believe, Townhomes North, SDP 17000002 in C59. Affordable Block 4 ASDP in S128 is Block 4 ASDP 18-00004. And Track D preliminary plat in S128 is Track D PP 18-00001.
Well, so, again, there are 5, I apparently didn't follow your testimony, so
if you look on C59, the 5 permits that are referred to in Jean Lynn's email are the 5 permits other than West Ridge Single Family South. They have slightly different names. The names evolved over time.
well, again, I'm confused because we're talking about 5 permits in process in September of 2017, and your chart only shows 4 polygon permits in process at that time. So is the chart wrong, or what?
So I think the confusion may come that the C59 was showing land use permits. South Townhomes construction permits, that's what she calls it, construction permits in Jean Lynn's letter, which is the first permit listed, already, you can see under status, it says SDP approved. So it was discussing the construction permits for Southtown Homes, not the land use permit.
Okay, so why was Jean Lynn involved in reviewing construction permits if the land use approval was granted in July of 2016, more than a year before she wrote her email?
Because the land use permit had been approved and Polygon was submitting construction permits, the planner who was the lead on this land use permit was no longer working for the city, and the construction permits were assigned to her.
What review does a land use planner give to applications for construction permits?
We're reviewing against the land use permit conditions. We're reviewing for setbacks, landscape, trails, other site improvements, as well as building any conditions from the land use permit that related to conditions.
And did the two planners who were assigned to Polygon, according to these emails, assigned to Polygon, were they ever assigned to work for Shelter?
Dan Martinez and Valerie Porter?
Yes.
No, they did not have sufficient experience for the level of complexity of Shelter's permits.
Did you at some point take over personal review of Shelter's applications from Jean Lynn?
I took over the preliminary plat when it was resubmitted, yes,
So when was that?
in March.
So Ms. Lynn processed all of Shelter's applications until March of this year?
I was discussing the plat, the land use permits. I'm not sure whether Jean worked on those once Shelter had identified that they were not going to use the replacement regulations.
Well, isn't it accurate that no one except you has processed the applications at issue in this hearing?
Jean Lynn worked on the pre-app submittals. And when I can't remember what may or may not have happened relative to the SDPs and ASDPs once they were submitted.
Well, let me make my question more specific. Ms. Sloman, isn't it true that at least since the replacement regulations were enacted, no one in your department has done anything to process any of the SDP applications at issue in this hearing except yourself?
Since the replacement regulations went into effect, I have handled the SDPs and ASDPs that this public hearing is, that are subject to this public hearing, yes.
Okay, so let's turn for a moment to the chart, the colored chart that I identified as an attachment to Exhibit S2127. Do you recognize this?
I imagine that I've seen it since it was attached to the email. I haven't probably seen it since then, but
Okay,
between now and then.
And it's labeled Jean's Project Timelines,
Yes,
and the first date on it is August 7 of 2017.
yes.
Shelter's plat is sort of right in the middle of that chart, correct?
Yes.
Okay, and there's a column in a yellow-orange color under August 7 that says pre-app. What does that mean?
I don't know. This was not my chart, so I'm not sure what she intended by that. I don't remember when your client may have submitted a pre-app.
Okay, well, we've had witnesses testify in this hearing that your department later retroactively deemed the application complete as of August 1. Do you recall that?
I recall that, although it's incorrect. We did not retroactively deem it complete. The development agreement states that if an applicant does not receive a request for additional information within 10 days of a permit being submitted, it is automatically deemed complete. And your client, as I understand it, they were not communicating with me, but as I understand it, insisted on having a letter of completeness. And so at the time when Jean prepared that letter, she dated it when it would have automatically been complete per the development agreement.
Okay, so again, specifically, the first documentation from your department that the application was complete came in October, correct?
It may have been. I didn't write that letter. I don't have it in front of me.
Okay, and so this is Jean's timeline for shelter. When does she anticipate issuing the staff report?
In December,
Of 2017.
yes.
This is the staff report that you haven't started drafting yet?
I don't agree with the way you're characterizing that.
Have you started drafting the staff report?
I have started working on the staff report.
Have you started drafting the staff report, Ms. Sloman?
I have started working on the community conference memo.
Does that mean you have not started writing the staff report?
I would not write a staff report before an action that's required to take place first.
And when do you anticipate writing the staff report that Ms. Lynn anticipated in 2017?
Well, so this document, if it is, I don't know what date it was prepared. Maybe that's clear in one of these emails, but if we assume since the first week that is shown on this timeline is August 7th, that means that this was likely prepared in early August, days after the permit was submitted, before Ms. Lynn had an opportunity to review it and to determine that she needed additional information. So this may have been a concept of how she anticipated doing it, and that changed when she did the review.
So why don't you turn to Exhibit 127, Ms. Sloman, and
Okay.
second page where Jean Lynn is sending you an email attaching to you a copy of her project timeline.
Okay.
What's the date of that?
September 8th.
And what review were you just referring to when Ms. Lynn would have realized that her timeline was unrealistic?
When the planner and the engineer, as well as other assigned reviewers, have completed their review of a permit, they would send out comments.
Well, what comments are you referring to, and when were they sent out?
So the comments on the preliminary plat, there was an engineering email that I believe went out in January, and then a set of marked up plans that went out in March 2018.
So you've referred a couple of times to this engineering review, Ms. Sloman. Do you have a copy of that?
Not with me this evening, no.
Yeah, I don't believe my client has seen any engineering review comments. So perhaps you could find those that you've referred to.
All right, I believe they may have gone to the engineer for the plat, but I don't know that for certain.
Okay, so the first comments on the plat application itself are the ones that were sent in March?
Not if an email went to the engineer who I believe applied for the permit in January.
Well, let's leave those engineering comments that we haven't seen to the side for one moment. I'm talking about land use review now. The land use review, the first and only communication regarding the land use issues was in March of 2018, correct?
The marked up plans were in March of 2018. I don't think that's the only communication.
So did my client receive anything before it got those marked up plans in March of 2018?
I'm not the permit lead. I don't know all the dates or activities associated with the permit.
I thought you became the permit lead on the plat. Did I misunderstand?
I did in 2019.
So what is this community conference memo that you apparently started drafting?
I'm sorry, say that again?
Referred to this, I believe, to a community conference memo instead of a staff report for the subdivision. Did I misunderstand?
So for a community conference, which is the first step in reviewing a plat application under the replacement regs, the first step is the community conference, and a memo is sent to the Development Commission.
And what does that memo talk about? Does it talk about what my client is vested to?
No.
Okay, so what does it talk about?
I believe, according to the IMC, it talks about, there's some general terms used, which I am not recalling specifically, elements that comply and don't comply. I'm not, I really don't remember. I haven't, I looked at it earlier this week or last week, but I don't remember the exact words.
Well, have you drafted this memo?
I've started working on this memo.
Okay, so, Ms. Sloman, can you find, please, the notice of application that your department mailed for my client's plat?
Can you give me a,
Well, it's in the record twice. I think one of them is S1.
okay?
Have you decided that my client is not vested to what is illustrated on that notice of application?
I would be glad through the plat process to talk about this. Our position has been stated in these proceedings that this was not part of the original submittal, and that we do not think that that gives it standing. But, you know, the issue I'm having is you're asking me to make declarative statements about things before I have completed my review.
Well, Ms. Sloman, it's 21 months since we submitted the plat application, and you've just, I think, acknowledged again you haven't decided what we're vested to?
So 21 months, of which 12 months it was out for corrections.
Ms. Sloman, you've already acknowledged that that's not true. So,
I'm sorry, say that again?
you said you've already acknowledged that that is not true. That is a gross exaggeration based on your own prior testimony. Isn't that fair?
I don't know what that means, that is not true. Could you clarify, please?
Yes. What is the 12-month period when you sent out corrections and my client was doing nothing in response?
I did not say your client was doing nothing in response.
Okay, what is
But may I finish, please? We were waiting for a resubmittal. We sent the comments. We were slow to respond the first time, and then about every 2 months, we had an exchange with your client asking for clarifications and additional information. After multiple exchanges, we received new drawings, revised drawings.
And how long was the period of time within that 12-month period when you were slow to respond?
I don't know exactly, 5 months, 6 months?
Now, Ms. Sloman, you testified last time, and I apologize, I'm trying to find the testimony here, but you testified that one of the problems with our plat application, it was in the context of why you were explaining why you were withholding a determination of completeness for the SDP applications. It was because of the pending, it was because the plat had not been approved yet, and you gave an example of a problem that the application showed some sort of easement in the location of a building. Do you recall that testimony?
Yes, there was on the drawings shown a public access easement in the area of parking and I believe a corner of a building.
Okay, well, the building that you apparently are referring to in your testimony didn't appear on the August application, did it?
No.
It only appeared on the December supplemental submittal, correct?
Well, true. However, the site development permit for the retail SDP, when I was reviewing that for sufficiency, I was looking at the area that was shown, and I could see, comparing the two, prior to the footprints being added by your client, that there was a public access easement in the area where other uses, such as required parking, were shown, and I was concerned that that relied on a council determination.
Well, Ms. Sloman, I think you just testified that you were reviewing our plat application together with the SDP applications and that they were consistent with one another, correct?
No, I was saying the opposite. I don't understand what you mean by consistent, I guess.
Well, apparently, they both showed a building in the same location. Is that fair?
I don't think I was using the December plans. I think I was using the August plans, and I don't remember whether the public access easement, whether it was shown on the plat or on the site development permit.
Well, Ms. Sloman, again, maybe we should take a break and I'll find the testimony, but you testified that it was the plat application that showed this discrepancy, and what you termed to be an inconsistency, and that was one of the reasons that you couldn't process the SDPs. It was because of the plat application. Isn't that what you said last time?
So this has all been, as you have identified, going on for a long time, and I have spent time during these proceedings, looking at the various plat applications that have come in August 1st, August 28th, December, and March. And at the time that I was reviewing the site development permit, I had to have been looking, that was submitted in November of 2017, so I had to have been using either the August 1st or August 28th submittal, plat submittal, and was concerned to see that there was an easement that I did not know if it would be released, and therefore it created uncertainty with the site development permit.
Okay, well-
Subsequently, I was able to look at it in your more recent submittals and see that a corner of a building was shown in that easement area.
Okay. So, Ms. Lippman, I'll find the testimony on the break. I'm happy to move on to another exhibit, or we can take the break now. It's your choice.
This would be a good time to take a 10-minute break. Appreciate it. Thank you. Okay, we're back on the order, or back on the air, and I'll call the meeting to order.
A copy of the transcript from last time. I'd like you to turn to page 22 where you were testifying, please.
Okay.
And your testimony starts on page 21 where you're testifying that Mr. Mullaney gave misleading and/or incorrect testimony, and I'll get back to that. But as part of your testimony on that issue, you started talking about the contrast between Polygon short plat and Shelter's preliminary plat. And so I'd like, you can read more of it if you want, but I would like you to specifically read what you testified last to, beginning at line 15 on page 22.
Shelter's preliminary plat, on the other hand, being a full preliminary plat, was much more complicated. There, because we aren't the decision maker, we don't know what the outcome is going to be. The plat showed a public access easement on areas that had parking in the corner of a building. We had no idea if that was going to be released, and so there was a great deal more uncertainty that came with a preliminary plat than a short plat.
Okay, so we also, I think, opened in front of you, to speed things along, a copy of City Exhibit 14, which is the plat application. You could take a look at that, please.
Okay.
And I think this is the one that was in November or December of 2017. Would you find for us, please, where the plat shows a public access easement on areas that had parking in the corner of a building?
This is only one page of the December submittal, and it isn't shown on that page.
You can look anywhere in the submittal you want. I'm asking you to
There's only,
identify.
C14 only has one page.
C15 is the next page. So I think the entire submittal is there. I'd like you to identify what you were referring to when you gave the testimony last time.
Okay.
And then when you find it, if you could identify the page, please.
So in C15, the very first page, which is labeled C15 Core Preliminary Plat High Street Collection at Issaquah Highlands, I don't see a label on what this sheet is. So I'm looking on, gosh, this is tiny. Lot 5, which is south of Ellis Drive, and across towards the west end of that block, it says public access and utility easement, and it points from the arrows, I believe, point from the north side of Ellis Drive to a dotted line south of the south edge of Ellis Drive.
Okay, so what is the easement that you're referring to, Ms. Sloman?
A public access and utility easement?
Is that an easement that the city required my client to dedicate?
I don't know.
Didn't your department require Polygon to get that easement from Shelter as a condition of one of their approvals?
I don't know that we required it. I wasn't the planner on that permit, so I don't know the process by which this easement was recorded.
And wasn't that easement worded in such a way that it went away when a public street was dedicated?
I don't know. I was not at that point reviewing the plat, and I have not dug into that level of detail.
Well, Ms. Lohman, you testified last time that one of the reasons that you weren't deeming my client's SDP applications was complete because the plat showed a public access easement on areas that had parking in the corner of a building, correct?
Yes.
And so you were obviously reviewing the plat application that showed a level of detail, including buildings and access easements and streets and parking and all of that, correct?
No, I was looking at it at the level of this kind of drawing. I was not opening up the recorded documents. I was looking at it and seeing what information was provided on an overview sheet such as this.
Okay, and isn't everything I just described, building footprints, parking, access easements, isn't everything illustrated on the document that you referred to?
So the document I'm looking at, C15, does not have building footprints on it. Let me say that the particular sheet that I am looking at this time, and the rest of C15 is not here. It's just that single sheet.
Well, what is the date of this material?
December, I think, 15th, 2017. Those are really tiny little numbers.
Okay, before you gave the public notice that included the building footprints, correct?
Was this drawing created before the public notice that went out? Is that your question?
I don't think that was my specific question, but if you want to acknowledge that to be the case, that's fine.
So the date on this drawing is December 15th, 2017, I think.
Okay.
And I believe public notice went out later in December. So yes, this drawing was created before the public notice went out.
Okay, so you referred before the break, Ms. Lohman, to Mr. Niven's April 4th, 2018 letter as having informed us what we're vested to.
I do not have that letter in front of me. I believe it spoke to some of the standards and vesting provisions, but I do not remember the specifics. I thought it had information that might be relevant to the question you were asking me.
Well, again, I've been asking multiple questions about what my client is vested to under the plat, and in response to one of those questions, you said Mr. Niven described it in his letter. Isn't that correct?
If I made such a general statement, that may have been inaccurate. What I was trying to indicate was that I remembered that April 4th, 2018 letter had some information on vesting and the plat. I don't remember the specifics.
Okay. That April 4th letter is the only communication the city has given to my client telling us what we are vested to or not vested to under the plat. Is that fair?
I don't know.
Okay, would you turn to Mr. Niven's letter? It's Exhibit S30.
Okay.
Okay, so first of all, I want to turn your attention to the top of page 2 of Mr. Niven's April 4th letter. You read the first sentence on that page, please.
Pursuant to IMC 18.19C.280 as adopted by ordinance number 2830, the city considers IHIFC's preliminary plat application, permit number PP 17-00002, to be vested to the extent indicated below.
Okay, and then if you could turn over, please, to the bottom of page 4 of the letter, section 5.
Okay?
Okay, and why don't you read what Mr. Niven wrote there? Read that first paragraph, the one that begins, "Under the state law."
Under the state law standards adopted in IMC 18.19C.280, a complete subdivision application vests the underlying proposal, quote, only at a very general level, close quote, i.e. to the land uses allowed under the municipality's current regulations, semicolon, parentheses, no, quote, any specific project will still have to meet the development standards at the time the building permit, with building permit underlined, is filed, period, close quote.
And that's a citation to a case, Alliance Investment. You don't need to read the whole citation. Pick up again where Mr. Niven's sentence is.
Where a plat application actually identifies a specific development plan or concept, such as building footbacks, setbacks, etc., quote, what is vested is what is sought in the application for a plat, close quote.
Okay, so Mr. Niven said that where, he quoted the Noble Manor case, that where a plat application actually identifies a specific development plan or concept, such as building footprints, setbacks, etc., that's what you vest to with a plat application, correct?
I think his wording is here.
Okay, didn't I fairly summarize it?
I suppose.
Okay, and the materials that we were just looking at that you referred to in your testimony last time with the plat application materials that you had in front of you in November and December before you sent the public notice, they showed a great deal of detail in addition to building footprints, correct?
So your client submitted additional unrequested materials that were beyond the scope of what was submitted in August when the permit was deemed complete.
Ms. Sloman, would you answer my question, please? Before you sent out the public notice, you had a thoroughly detailed plat application that gives considerable more detail than Mr. Niven's letter says is required to vest. Isn't that correct?
Your client was hoping to submit that to vest to an additional level of detail beyond what they originally submitted, I would assume.
Ms. Sloman, would you answer my question, please? Didn't you have a detailed, thorough plat application before you sent out the public notice?
I would say it was beyond the detail that we need for the plat. I would not say it was thorough. I would say it was excessive.
Okay, and you've had that detail for a year and a half, and as you told us earlier tonight, you have not decided what of that detail we are vested to, correct?
I'm not prepared to make a statement in these proceedings that are not about the plat regarding matters that we will deal with through the plat application review and decision.
Are you declining and refusing to answer my question, Ms. Sloman?
Could you state your question again, please?
Well, why don't we have the court reporter read it back, please?
take 1 second, I need to change my spacing here. It's on this, my page is.
I know we're not that far in, but might I suggest taking a quick break so that he has time to correct the technical issue and
No objection from the city.
5 minutes?
Sure.
5 minutes, let's take a break for 5 minutes. Okay, we're back on the air, so I'll call the meeting back to order, please. Would you please re-instruct the recorder?
I think I asked you to read back the question, please.
Yeah, I had a glitch there. I'm recording, but everything was not on my feed.
Okay, all right,
That was my problem, I'm sorry.
okay. So, Ms. Lohman, after this interval, I don't specifically remember the question I asked, so you don't have to answer it. But let me try it again. The plat application materials that you referred to in your testimony last time as an example of why you weren't willing to deem Shelter's SDP applications as complete, in fact, provided a detailed set of plans and informations that is consistent with the SDP applications. Isn't that fair?
No, the SDP submittals that I was reviewing came in late November before your client unilaterally submitted these additional materials. And so at the time, I was looking at the August submittals, trying to understand how they related to the November SDP submittals.
Ms. Lohman, I don't think you answered my question. My question was about the material you had in November that we were talking about before the break that you referred to in your testimony last time. That material is consistent with my client's SDP applications, is it not?
So I think before the 10-minute break, I maybe more accurately characterized what I was trying to say. There are two things kind of happening because of the period of time we're looking at. There was what materials I looked at in November when 2 of the site development permits were submitted. And the only plat materials that were available were the two August plat submittals, which did not show building footprints, but did show the public access easement. When I testified last time, I think I was thinking more comprehensively based on all of your plat submittals, and what I could see in the December and March plat submittals relative to this easement and the buildings and parking and detail that you referred to.
And Ms. Lohman, you're still not answering my question,
I'm trying.
which is a simple one. Materials that you, and by you I mean not only you personally, but your department had November of 2017 are consistent with my client's SDP applications and show a great deal of detail about building footprints, roads, easements, parking, and so forth. Isn't that accurate?
No. The plat with that level of detail was not submitted until December.
The document that you were testifying about, you told us had a November date on it, correct?
I'm confused. The November permits that I'm referring to are the site development and administrative site development permits that were, the first two that came in November. I don't know, the 20th, the 23rd. There was no new plat materials submitted in November. There was only the plat materials from August.
Let me direct my question then. In December, you had not only the detailed STP application materials, but you also had a plat application that was consistent with those materials, correct?
We did. As I think I have testified previously, I did not get notice that those new plat materials had come in December. I was not reviewing the plat at that time. I was not aware that those materials had been submitted. I was reviewing the STP submittals against the previous letters that had been sent out. I don't think that I was pulling up the new plat submittal materials that had come in subsequently.
Okay, so I think you agreed that you had that information in December, and by you, I mean your department. And when you testified last time about a problem with the plat, you were in fact referring then to the STP application and not the plat application?
So without looking at those materials, I don't know which materials had the easement. I know that the August plat showed the public access easement. I mean, I should say I feel fairly confident. I haven't looked at it in many, many months. The SDP, I don't know if it showed the public access easement or not. I would have to go back and look at those documents to be able to conclusively answer your question.
My question, I think, right now is a simple one. And I'm just trying to find out whether last time about issues raised by the plat, whether you were referring to the plat application, as you said, or whether that was a mistake and you were referring to the SDP application.
So I was referring so I was conflating a number of things, and so I can understand that's confusing. My initial awareness of the public access easement, I believe, was when I began looking at the November SDP and ASDP submittals. However, by the time I was testifying last time, I had looked at many different plats and SDPs and had seen among those many documents that the surface parking, the corner of a building, and the public access easement overlaid each other. I, at this point, am not clear which document I was looking at when I was referencing that last time, because I was not speaking to it as a specific submittal. I was speaking to it as a concern about whether that public access easement would be released, and that at that point in time, having seen many documents, I could see that there was overlap between some of the elements your client was showing and that public access easement.
Would you turn to Exhibit S65, please? so this is an email from you to Jean Lynn.
I think so. The part of the to and CC and from are cut off, so it's hard for me to see the whole thing, but in the body of the text, it does say Jean and Lucy.
Okay, and you told Jean that she did a great job of getting out a combined notice of applications for 3 permits, including the Shelter High Street plat.
I did.
And then you say the date on the document says December 27 of 2017?
It does.
Then you say, now that we have these 3 permits assigned to 3 different planners, can you catch us up on what has and hasn't happened associated with this?
It does.
Okay, so when you told her that she'd done a nice job, had you reviewed the notice of application that you complimented her on?
I did not, I had, I believe, written the text for West Ridge North. I believe she had written the text for High Street. I provided her with the exhibit for West Ridge North. I believe she provided the exhibit for the shelter plat. I did not look at the exhibit part. I was looking at the text part.
Okay, so when you complimented her on a nice job, you hadn't in fact reviewed what she'd sent out?
As I said, I reviewed the text part, but not the exhibit part.
So, I'm sorry, which of these plats did you write the text for?
I believe West Ridge North, single family.
Didn't you testify last time that you wrote the text for the High Street plat?
I don't remember, so I don't remember testifying to that or that I wrote the text for that.
Okay, but the High Street, your testimony last time will speak for itself, that the High Street plat is the shelter plat, correct?
Shelter High Street plat is your client's plat.
Why don't we turn to another exhibit that you prepared, Ms. Sloman, and offered last time. It's Exhibit C60. Could you turn to that for a moment?
Okay?
Okay, so remind us what this document is that you prepared and why you prepared it.
I was trying to illustrate the timing of when pre-application packages were submitted, when pre-application meetings took place, when site development permits were submitted, when sufficiency letters went out, and relative, so when those actions took place relative to communications between your client and the city regarding whether a pre-app was actually required.
Okay, so in the right-hand column, you have an entry. I believe what it tells us is that on November 6 of 2017, you wrote, Keith says no pre-app required.
That is what it says.
Okay, so I haven't been able to find a document dated November 6 of 2017 that says that. Have you offered that document into the record?
No, your client testified to that.
Which, you saying Ms. Hine testified to that?
That's my memory, yes.
Okay. Remember when she did that?
There were many evenings, so I don't remember specifically which one.
Okay, would you turn, please, to Exhibit C50?
Okay.
Okay, so you believe that Keith told us that no, Mr. Niven told us no pre-app was required based on your memory of Ms. Himes' testimony?
Yes.
When you prepared this chart, did you go to the transcript to see whether your memory was consistent to what she testified to?
Well, I prepared that exhibit a number of weeks ago, I believe. I don't know whether I looked at the transcript or my notes from the evening.
Okay. So why don't we talk about Exhibit C50 for a moment. You recognize this?
I do.
It's an email chain back and forth between you and Mr. Niven and copies to, well, there are several people involved. You, Mr. Niven, Patrick Mullaney, James Haney, the city attorney, Emily Moon, Bob Harrison, John Shaw, correct?
The last email on November 1st was from Keith to Tia, and with CCs as you identified.
Okay, so let's turn to the third page of this exhibit. The top email on that page is one from you to Tia Heim, correct?
Yes.
Why don't you read what you wrote there to Ms. Heim?
The city's position is that meetings we are discussing with you are provided in the development agreement, though they have different names. They are marked optional, and that decision is at our discretion. We believe they benefit everyone in improving the conformance of the SDP submittal to the development agreement. Regards.
Okay, so on October 27th of 2017, you were telling Ms. Heim, were you not, that it was up to the city, your discretion, whether they had to participate in a pre-app, correct?
On October 27th, yes.
Okay. And then let's turn to what Mr. Niven said in the email on November 1 that he sent to Ms. Heim and copied you and the others we've referred to. So Mr. Niven begins, does he not, by saying, I'll quote, your first point is that the pre-application meetings are listed in the agreement as optional, period. This is true. And then he refers to Appendix L, correct?
Yes.
And then why don't you read what Mr. Niven wrote in the next two paragraphs?
In the next paragraph?
Next two paragraphs.
However, since Port Blakely chose to stop funding the MDRT as a separate permitting entity within the city administration, changes had to be made. The city funded a reorganization study performed by Moss Adams in November 2011 that looked at how the city could continue to permit the remaining projects in Issaquah Highlands with existing city staff. It was decided in 2012 that the MDRT would cease to exist and permitting of the remaining Issaquah Highlands projects would be undertaken by city staff. Under existing city processing, the pre-application meeting is not optional, it is a required part of the process. City staff use these meetings to help define the requirements for a complete land use permit submittal. One of the reasons Lucy stated that the pre-app meeting was mandatory is for this reason. In other words, neither Lucy nor I can envision how to determine a complete project submittal without having a pre-application meeting. To my knowledge, all land use applications in Issaquah Highlands have gone through a pre-application meeting. The city views this meeting as necessary to be able to efficiently process permit applications.
Okay, so Mr. Niven refers to you saying that the pre-apps are mandatory, and he says that neither you nor he can envision how to determine a complete project submittal without having a pre-application meeting, correct?
In this email on November 1st.
Okay. But again, you don't have any city document, you don't have any independent regulation, you don't have any basis for saying, we're preparing this chart saying that Keith says no pre-app required except your memory of Ms. Heim's testimony?
Well, I would disagree. There was Ms. Heim's testimony, but also, which is the pre-app chart that we were looking, oh, here it is, C60.
That's what I'm referring to.
So the pre-application as shown on C60 for the retail The pre-app was submitted on October 23rd. The site development permit was submitted on the 22nd. The letter on the site development permit being insufficient went out on December 1st, and the pre-application meeting did not take place until the 5th. In the letter on December 1st, while we identified many elements that were insufficient related to the SDP applications, the pre-app was not one of those. So by December 1st, it was very clear to me that we were not requiring the pre-application meeting and did not include that as an item in that letter.
Okay, so the evidence that you're relying on, in addition to your memory of Ms. Himes' testimony, is a document that doesn't refer to the pre-app as something that needs to happen? It's basically a negative because it doesn't refer to a pre-app. That means the city told my client a pre-app wasn't needed?
In the sufficiency letter, as we've identified, the submittal requirements are a guide for all the many things that we may need to review each individual permit. And as we review an application, we're looking at the submittal requirements to determine whether certain elements that are listed on there are applicable to that particular permit. And based on the discussions that had taken place previously, I did not identify that a pre-app meeting was necessary because I understood that we had moved past the previous emails and concurred with your client.
Okay, and first of all, your chart demonstrates that a pre-app meeting happened for all of my client's SDP applications, correct?
Yes, even though they were no longer being required.
Okay, and the Exhibit C50, in which Mr. Niven tells Ms. Heim that, in effect, an application can't be deemed complete without a pre-app meeting, that's the only communication I'm aware of in the record on this issue. So again, I just want to make sure that we're not missing anything. You can't point to any communication to my client in writing that says, that rescinds what Mr. Niven said on November 1st, modifies it, changes it, says your department can determine an application is complete without a pre-app. There is no such document, correct?
I've already testified that your client, Tia Heim, testified otherwise.
Ms. Sloman, my question was whether there is a city document that revises what Mr. Niven said in his November 1st email.
A city and when you say city document, could you help me understand what you mean by that?
Document prepared by the city, communicated to my client.
So Mr. Niven's email on the 1st says it is optional, but we still consider it mandatory. Ms. Heim, in I think her meeting notes, but I'm not certain, but in her testimony said that she was told that by Mr. Niven on the 6th, which is why that date is listed here. And then by not including it as an element in our insufficiency letter, that reiterated that we were not requiring that.
I take that as a no, there is no city document, since what you referred to is Ms. Heim's note, correct?
Well, the letter didn't require it.
The letter didn't talk about it one way or another, did it?
No.
So, Ms. Solomon, last time you talked about the city having accepted a building permit and a land use application in addition to the Vale project that we previously talked about, and that the city was conducting concurrent review. Recall your testimony on that issue?
I recall we talk about it. I'm not sure I remember all the details of it.
Well, I'm referring to your testimony, and you told us by way of an example of how the city doesn't enforce the requirement that you have to have a land use decision before you can apply for a building permit. You referred to a project currently being given concurrent review by your department, correct?
Are you referring to Vale or another project?
I'm referring to another project that you referred to last time without identifying for us.
I may not have identified it last time. I did look at that
Okay.
subsequently.
And what's the name of that project?
I believe it's called the Sunset Duplex.
And Ms. Heim, at my request, printed out today from the city's website, an active projects list. Would that document contain what you just referred to?
I don't know. The active projects list is not comprehensive. It doesn't include every project. It contains a selection of projects, and so I don't know whether that project is listed or not.
Okay, well, I'm going to represent to you that this project list, and I'm happy to make it an exhibit, does not include any project that, as you described it in your testimony last time. So would you give us again the details of this project that you described with the concurrent review?
The recent one that we're talking about, the Sunset Duplex?
If that's what you talked about last time, yes. Sunset what?
I think it's called the Sunset Duplex. And the applicants submitted their land use permit, and it has not yet been approved, but their building permit has been submitted and is currently in review.
And what do you know about this project?
It's on Sunset Way. It's a duplex. It is 4 stories tall, which is why the property owner or the heir submitted the building permit, because they had heard that the city might change the regulations to not allow 4-story buildings, and so they wanted to submit a land use permit to be vested.
Okay. And do you have personal knowledge of this application?
I have been working with a staff person who's reviewing it.
Okay. And who's that staff person?
Valerie Porter is the planner. There is also an engineer and a plans examiner and other city staff that I am not sure who those people are.
Okay. And who made the decision to accept the building permit application despite what's on the city's webpage?
Well, consistent with 1801050, I don't know who. It may have been the permit tech, it may have been the building official, it may have been the planner. I was not, all I heard was these had both been submitted, and we discussed how to do that review concurrently, and it proceeded.
Okay. And so if I look up this project on the city's webpage, it will reflect what you just testified to?
I don't know that it's on the active projects. I assume that you could find it through mybuildingpermit.com, but I don't know the level of information that's accessible to the public.
So what goes on the active projects list?
Well, I would say moderate to large-size projects. The permit oversight coordinator is the person who manages that map, and so I don't fully know how she makes that determination.
So, Ms. Lohman, going back to your chart again, the one that you prepared for this hearing, which is
Do you mean the large one?
the large one, yes.
Okay.
Here it is.
Can you give me the number?
Yeah, C59.
Okay.
Is it your testimony that all of the projects on this chart that you prepared were treated the same way by your department?
Well, it depends on what you mean by treat the same way. We try and process all of the permits based on their complexity, their need for corrections. There are many different factors that come into play in terms of how long it takes to process a permit. I believe that that is not based on, I think you've used the word discrimination. I do not believe that there is discrimination, but that does not mean each of them are processed in an identical amount of time.
So, again, you didn't treat any of these applicants show favoritism to any of them. You simply applied the regulations in the same even-handed way.
We applied the regulations in an even-handed way. Yes, I believe so.
Okay, I'm going to hand out 2 exhibits, please. First of these, S-129, which is an email from you to Ms. Sloan, from Ms. Heim.
Okay.
So, Ms. Sloan, in her email on January 26th, it begins at the bottom of the first page, is asking to meet with you. Is that correct?
I believe you said Ms. Sloman. I think you mean Ms. Heim.
I apologize, yes. Ms. Heim is asking to meet with you, Ms. Sloman, early next week to clarify what is required for the MOB, the medical office building application.
Yes.
And your response, again, just the first sentence of your response is you're not able to meet early next week?
Yes.
What's the date of your email to Ms. Heim?
The 26th.
I want to hand out exhibit S-180, or excuse me, S-130, please. S-130 is an email exchange between you and John Haas, correct?
After John emails it forwards it, I assume, to Tia, the next email is from me to John Haas.
Okay. And Why don't we go down to the bottom of the first page and the top of the second page. You emailed Mr. Haas on January 22nd, or excuse me, January 27th, correct?
That was on the 27th, yes.
That was the day after you told Ms. Sloman in Exhibit S-129 that you weren't able to meet early next week?
So that's Ms. Heim again. Yes, I did say that.
Okay, and then, so what did you tell Mr. Haas a day later? You could read the first sentence of your email to him the next day.
On the 27th?
Yes.
I'm out of the office starting Wednesday, but I would very much like to meet with you Monday or Tuesday to discuss the status of your project.
So on Friday, you tell Ms. Heim that you can't meet with her next week, and the next day you tell Mr. Haas you would very much like to meet with him to discuss the status of his project, correct?
That is correct.
And in fact, Mr. Haas's project was reviewed and approved in the space of, it may be the quickest turnaround and review of any of the projects on your exhibit C59, correct?
It might be. I don't have specific lengths of time on here.
Okay, and you were in fact reaching out to Mr. Haas repeatedly to make sure that he vested, correct?
I was trying to make sure that Mr. Haas understood the implications of things that were happening. He was not a land use attorney. He never brought a land use attorney to any of our meetings. And this was, as I understood it, the first project that he had, development project he had gone through. So I was concerned that he might not understand the implications of what was happening.
Well, he was specifically questioning you about vesting, wasn't he?
I don't know. I have not read this email.
Well, why don't you look, turn to the third page and his email to you the day before you emailed him saying you would very much like to meet with him on Monday or Tuesday. And he's asking you about statutory or case law regarding vesting, isn't he?
Yes, he is.
So, Ms. Sloman, you testified last time about how
Could I add one thing to that discussion? Because you've characterized that I treated John Haas differently than your client. And I would like to add that based on one of the exhibits that the city provided at our last meeting, an email between myself and Patrick Mullaney discussing the terms of the letter that would ultimately provide your client with a complete application. Patrick was, he and I began, the email that was submitted last time, those emails were from January 12th. I don't know the exhibit number. I can look it up if that's useful to you. But while I was waiting for that letter to be completed, my concern with meeting with your client was that I was not able to proceed until that letter was completed. I don't believe I said that here. I don't know because I haven't read it in detail. But I knew that that was taking place, and that was going to be the tool to get us to your client's applications for SDPs and ASDPs deemed complete.
So, Ms. Sloman, you testified last time at length that if the administration, or if the city council had accepted the administration's recommendation regarding vesting, that we wouldn't be here? Is that correct?
Well, I said that initially, and then I said we would be here with a different kind of meeting on the permits.
Okay, but the point is, you were telling us last time that the administration recommended one thing and the council chose to do something else, correct?
In 2017, the administration had recommended one form of vesting language, and that was not the vesting language that was ultimately adopted.
The administration, including you and Mr. Niven, changed its recommendation in early 2018, correct?
Yes.
And
Although I would, I am not a part of the administration, I am a part of the city, and so that recommendation is the administration's recommendation.
well, Ms. Lohman, you are part of the administration. Everyone who isn't part of the council is part of the executive branch of city government who reports to the mayor. Isn't that correct?
I don't think I'm part of the executive branch. I do report to the mayor, that is correct.
Okay. Well, I submit you are part of the administration, and if you don't want to accept that, we'll deal with that later. But nonetheless, the administration, whether you consider yourself part of it or not, in fact, changed its recommendation in early 2018, and what the council adopted was what the administration recommended, correct?
Yes.
And so who made the change who decided that the administration's recommendation had changed?
There were a number of people discussing that, and I don't know whether I was a part of that discussion.
Well, isn't in fact true that the mayor, the new mayor, decided that the administration was changing its recommendation?
I don't know that she decided that unilaterally. I think she decided that, as we often do, we have it's, as I said, I don't know that I was a part of that conversation, but a number of people were talking about whether that would continue to be the city's recommendation.
The mayor, you will agree, is part of the administration, correct?
Yes.
Okay, so why don't we go back to Exhibit S-130 again, which is your email exchange with Mr. Haas, in which you told him you would very much to like to meet with him on Monday or Tuesday.
Okay.
And so the last email in this chain is one that you sent to him on January 29th, which was Monday, correct?
Yes?
And,
Oh, wait. The last email, yes.
okay, and you were responding to an email from Mr. Haas the same day, who, I'll read it. He says, "Lucy, what was the administration's reason for taking the vesting options off the table? The only negative feedback I heard was from Craig Ramey at the council meeting." Correct? Is that what he said?
He does say that on Monday.
Okay, and then how did you respond to John Haas?
I don't know. These kinds of changes happen with changes in administration. I believe you should contact the mayor and discuss it with her. However, I would like to meet with you tomorrow if possible to discuss the status of your project.
Okay, so you reiterate your request to meet with him, and you say he should contact the mayor if he has questions about the change in the recommendation regarding vesting, correct?
I did.
And was that an accurate statement on your part?
Which part?
That the mayor was the person responsible for the change in the administration's position regarding vesting?
I don't think that's what this says.
Well, you're right, that's not the literal language. That's my inference from what you intended. Did you intend something differently?
I intended that the mayor was willing or asked to be the person who would explain that, not that the mayor was the only person who had, was the only person who had made this decision.
So what communications did you have personally with the mayor about this?
I'm not sure I had any.
Well, what was the basis for you telling Mr. Haas that he should contact the mayor and discuss it with her?
I think that we anticipated that various property owners would want to discuss that change with someone, and we discussed how best to approach that, and the language that's in here is what we decided was the best way to communicate with applicants or property owners.
Who is the "we" we're referring to? Who did you discuss? Who was the "we" who decided that the mayor would answer questions about the change in recommendation?
I don't know who decided that. I believe when I asked because I believe I said something similar in my interested parties email, and Mr. Niven and I were discussing anticipating that there would be concerns, and I said, what do you think we should say? And we talked about it, and this was, and he may have even talked to the deputy city director or the deputy city administrator and the mayor. I don't know, but in the process of trying to determine the best way to communicate with the interested parties, that was the conclusion we reached.
So this email to Mr. Haas is based on a conversation you had with Mr. Niven?
Ultimately, yes, but I think there were several conversations that took place that culminated with that conversation.
Okay, well, I'm asking you who in the administration you discussed this issue with, the change in the recommendation regarding vesting. You've identified Mr. Niven. Who else?
I did not talk to anyone else in the administration.
So you had a series of conversations with Mr. Niven.
Yes, and I understood he was talking with others in the administration.
Okay, and did Mr. Niven tell you what the mayor's position was on this?
I don't remember I don't remember something that specific, no.
Okay, but it's from Mr. Niven who you learned that it was the mayor who was going to answer questions, correct?
Yes.
And who do you consider to be part of the administration if you're not part of it?
I consider people in the executive suite, the mayor, the city administrator, the deputy city administrator, some of the assistants to the mayor or the city administrator. I don't remember the exact titles of the people.
Is Mr. Niven part of the administration, in your view?
I do not, I consider him a department director, which is different than who I consider as part of the executive office.
Okay, so you don't consider Mr. Niven part of the administration then?
You know, you're asking me to put such a fine point on it, and I don't think about it at this level of detail.
Is there anything in a code or a director's rule or any kind of writing that says who is in and who is out of the administration?
I would not know that.
So when the,
Before you proceed, we've been going for a bit longer now. It seems like it might be if you're going to change direction a little bit, it might be a good time to take a 10-minute break, if you would.
No
So,
objection.
Agree. Thank you.
thank you.
Leave it there, Derek.
expedited a little bit.
Yeah.
But that's okay. All right, we're back on the air, and let's come back to order, please.
Have a new exhibit we're passing out. It'll be S-131.
Thank you.
Sorry.
This is a memo from you to the Land and Shore Committee dated January 30, 2018.
Was that a question? Yes.
So I'd like to direct your attention to page 2, section 3, entitled Vesting.
Okay.
Why don't you read the last sentence of that, the sentence that begins with the word however, about 2/3 of the way down.
However, after consideration and comments received, the administration has recommended not expanding or continuing the vesting, which naturally terminates with the end of the contract, i.e. the development agreement vesting would be limited to that required by state law.
So when you wrote this sentence, who did you mean by the administration?
I've been informed that I am part of the administration, so I concede to that. In this case, it was the same conversations that we've already gone through. It was, I am writing a memo to communicate a larger group's conversation.
Your personal communications were only with Mr. Niven?
Yes,
Did you have
as I
any,
remember them.
did you discuss the vesting issue with any of the council members?
Not outside of the, not that I remember outside of the meetings.
Didn't have a meeting with Ms. Goodman in her office?
I've never been to Ms. Goodman's office.
You didn't have a meeting with her in any other location about the vesting issue?
Gosh, I don't know. I don't remember that. If you have a record showing otherwise, I've forgotten that I met with her. I don't remember that.
Well, the question is based on statements that Mr. Niven made to my clients, so we'll be presenting that in our rebuttal testimony. I'm just asking you now whether you remember such a meeting.
I don't.
Last time during your testimony, you presented 2 newspaper articles. Do you recall that?
Yes?
About meetings that my client had with the community that you didn't attend.
Yes.
What's your relationship with the editor of that, I'll use the word newspaper?
She served on the Urban Village Development Commission for a number of years, where I was frequently before her. She served on the city council. She writes articles for the various newspapers, and she would contact me to discuss those articles or to interview for content. And I believe one time we went and saw an urban planning movie together.
In fact, she runs the content of her articles about land use issues by you before she publishes them. Is that fair?
Sometimes she asks me to fact check them.
Okay. Were you involved in the preparation of the 2 articles that you offered into evidence last time?
I do not remember seeing those before they were published.
When did you first see those articles?
As I just said, I don't believe I saw them before they were published.
So you saw them back when they were published?
I believe so. I don't know for sure, but I believe that I read them around that time.
So you testified last time that you were critical of Mr. Mullaney's testimony and that it was misleading. What did he testify to that was the basis for your comment that he gave misleading testimony?
I believe my memory is that he characterized what was the short plat for Polygon as a preliminary plat.
Well, the city gives preliminary approval to both plats and long plats, short plats and long plats, doesn't it?
I don't know what that means, preliminary approval.
For a long plat, there's a hearing. Let me be more technically correct. For a long subdivision, there's a hearing in front of a body such as the city council or the hearing examiner, and they make a decision about, they grant preliminary approval and tell the applicant what the applicant has to do before he or she can record the final plat, correct?
Yes.
Doesn't the exact same thing happen with a short plat? It just happens administratively rather than in front of a quasi-judicial body?
Well, land use permit decisions identify whether a permit is approved or not approved, and if it is approved, whether it is approved with conditions. A short plat notice or decision is made by staff, and it may or may not contain conditions. I would typically not expect it to contain conditions, whereas a preliminary plat, because a short plat would be recorded, there is no subsequent process like a final plat. Preliminary plat is the hearing may be before a commission or a hearing examiner, and the decision is either by a hearing examiner or the city council, and it does contain conditions. I think the distinction that I was attempting to make was that because the decision maker in a long subdivision is not staff, we do not know what the outcome of that decision will be.
Well, again, what I'm trying to understand is the basis for your saying that Mr. Mullaney gave misleading testimony. And what I've heard is you're suggesting that he didn't understand the difference between a plat and a long plat? I mean, a short plat and a long plat?
No, I'm sure Mr. Mullaney knows the difference between the two. I think he either misremembered or was misinformed about what the permit was, that Polygon process that he was referring to.
So you think he referred to a long plat when he should have referred to a short plat?
I believe so, yes.
Did you review his testimony before you testified last time?
Again, I was referring to my notes.
Again, just to be clear, you're not suggesting, are you, that, well, first of all, let me represent to you that under state law, the plat is the document that is recorded. That actually one finds when one goes to records and elections to see what lots were created. Are you saying that when there's a short plat involved, the city doesn't exercise any review over whether that plat as recorded is consistent with the decision that the city made?
I'm not following that question. Could you restate it, please?
Well, again, I understood you to say that a short plat is a one-step process, that you make an administrative decision and then you're done with it. And what I'm suggesting is that, in fact, the city, whether it's a short plat or a long plat, imposes conditions, and then before you allow the plat to be recorded and actually create the lots, you make sure that the conditions that were imposed in the short plat decision are complied with. Isn't that fair?
You're correct on a short plat in the city, because there is often a delay. Well, not often, there can be a delay between when the decision is issued and the property owner or applicant decides to actually formally short plat the property. At Issaquah Highlands, it is, in my memory, I don't remember that happening. It is typically that we are getting, we're making a decision, the Mylars are submitted with all the corrections that have been given. I don't know that we're typically using the notice of decision to convey the conditions. We are typically providing those as comments to be corrected before the Mylars are recorded.
Ms. Sloman, you've testified that all of your processing of Polygon's applications pursuant to the procedures in the development agreement was a mistake. Have you notified Polygon of your mistake?
So I don't know that I said that all of their processing of their permits was incorrect. In terms of their two preliminary plats, I believe after that I wouldn't have known that until after the appeal period. So my guess is that the appeal period had closed, so my guess is I haven't communicated that to them.
You're guessing you haven't told them that the process was unlawful given your current view of things?
Unlawful? I don't know that I would say unlawful. It was in error. I don't know that I have communicated that to them.
So you said you weren't sure all of the Polygon projects had been processed pursuant to the development agreement procedures. Which one was not?
I'm sorry, could you state that again, please?
Well, I'm just trying to understand what distinction you drew. Are you saying that some of the Polygon projects on your chart were not processed pursuant to the procedures in the development agreement?
I think I was trying to identify that, as I testified last time, the two preliminary plats, the West Ridge North Single Family and Parcel D, that those were processed using the procedures of the Issaquah Highlands Development Agreement when they should have been processed using the replacement regulations.
Well, in fact, you treated all of Polygon's applications on your chart as vested to process the procedures in the development agreement, didn't you?
Yes, and I think you do not agree with our characterization or our identification that the Affordable Housing Development Agreement tied many of their permits to the process under the Issaquah Highlands Development Agreement.
Well, Ms. Sloman, again, you have testified that it's now your opinion that one can't vest a process. So are you saying it's different according to whether one vested to the development agreement or to another document? That you can vest a process pursuant to one but not pursuant to the other?
I'm sorry, can you state that question again, please?
You've testified at length, particularly at the last hearing, that it's now your opinion, arrived at sometime presumably in March of this year, certainly within the last few months, that one cannot vest a process. And you, I believe, just drew a distinction and said that one can vest a process if one vested, if Polygon vested to this other development agreement, but not to the Issaquah Highlands development agreement. And I'm just trying to clarify that that's what you said.
I take your point. I don't know. We have focused on the plats. We have not focused on the other permits in terms of whether the processing was correct or not, and so I don't have an answer at this time.
Okay, thank you, Ms. Sloman. That's all I have for this evening.
Mr. Chairman, I'm happy to begin my redirect if that's the commission's preference.
That's our preference.
Thank you. Ms. Sloman, do you recall your testimony in response to applicant counsel's questions concerning the extent to which the city determined that their projects vest to substance, at least with respect to their plat, as opposed to procedural matters?
Their testimony or mine?
Their questions and your testimony.
Yes.
Okay. And if I understood your testimony, your position was that for purposes of the plat, the city would deem the plat application to be vested to substance under the development agreement, but not to procedures once the development agreement expired. Is that
Yes.
correct?
That's what we said about
And do
the
you remember
plats,
the
yes.
back and forth between yourself and Mr. Schneider on that point?
Yes.
And the insinuation that that was inconsistent with the city's previous position, do you recall that from the questioning?
Yes, I think so.
Could you please turn to Exhibit C44?
I closed it too soon.
These are the various meeting notes or minutes that were introduced into evidence and originally prepared by Ms. Heim. Could you please turn to the meeting minutes from the March 21st, 2017 meeting?
Yes.
What's the heading? It was the
March
March 21st,
21st.
2017?
Thank you.
What's the heading of that document, Ms. Sloman?
Meeting City of Issaquah collaboration meeting for our BSP and plat application.
Could you please turn to the fourth bullet point of that document and read aloud the text beginning with Keith added?
Keith added that his belief is that we vest to land use regulations but not to process. So he thinks that if they later change process, including getting rid of UVDC, which they want to do, we'd have to follow the code.
Thank you. Do you remember the original testimony you gave regarding Exhibit C64, the version of the development agreement that I believe you indicated was listed on the city's website and made publicly available that way?
Yes.
Do you remember Mr. Schneider's questioning of you concerning that document?
Yes.
Okay. In your understanding, Ms. Sloman, is the document referenced at Exhibit C64 more complete and more up-to-date and more current than the version of the development agreement that is contained at Exhibit S25?
Yes, I, subsequent to my testimony last time, looked at this document more closely to consider Mr. Snyder's question, and what I noticed is that about 80 to 90% of the track changes that are in here are followed by one of two references. It's either AM or AMM, which stands for an administrative minor modification, and it's the specific number of that permit that changed text, or the other reference is often action memo. I think even some of the major modifications that were approved by council some of them are also referred to in here. So while it is correct, this was never formally adopted because I believe the master developer did not want to invest in that. I think what we were trying to do with this document was up to the date when we stopped, we had compiled changes and reference them so that if someone questioned that reference or that change, they could go look at it for themselves and see if they felt that this was an accurate representation.
And approximately how long has that document been publicly accessible on the city's website?
I think we put it up around the time that the replacement regulations were being reviewed, so probably sometime in 2017, but I don't remember exactly.
Has anyone ever objected to the city, to your knowledge, regarding the accuracy or completeness of that web document?
Not that I'm aware of.
Okay, you again recall your testimony concerning the extent to which the city treated the polygon applications as being vested to the procedures under the development agreement?
Yes.
Okay. And if I understood your testimony, Ms. Sloman, you indicated that in retrospect, it was a mistake to process the polygon applications under those procedures?
Plats, yes.
Plats, okay.
I think that was the only part that we were talking about at that time.
I'd like to call your attention to your April 15th, 2019 letter. I believe that's at Exhibit S 113.
Okay.
Do you recall your testimony regarding this?
Some of it, yes.
Okay. Could I please turn your attention to the quotation and citation on page 1 of your letter to IMC 1819B 280, about halfway down the page?
Yes.
Okay. In the reference in number 3 of that quotation to a development agreement per RCW 3670B 180, do you see that?
Yes.
I'm going to hand you an electronic version of the cited RCW provision. Could you please read RCW 3670B180 aloud?
Is that the thing under notes that's in findings? Okay. 36.70B.180, development agreements dash effect. Unless amended or terminated, a development agreement is enforceable during its term by a party to the agreement. A development agreement and the development standards in the agreement govern during the term of the agreement or for all or that part of the build-out period specified in the agreement, and may not be subject to an amendment to a zoning ordinance or development standard or regulation, or a new zoning ordinance or development standard or regulation adopted after the effective date of the agreement. A permit or approval issued by the county or city after the execution of the development agreement must be consistent with the development agreement.
Thank you. Ms. Fleming, are you aware of any other provision of the replacement regulations, Chapter 1819B IMC, that cites any provision of the RCW concerning development agreements?
I don't know. There might be something in the introductory material.
Are you aware of any other citation to Chapter 3670B RCW in the replacement regulations?
I would doubt it, but I don't know for certain.
Thank you. Turning to the final page of your April 15th, 2019 letter, again, Exhibit S-113, and the bolded asterisked text beginning with, "Please note," right above the signature block. Do you remember your questioning on that point from Mr. Schneider?
Yes?
Okay. Ms. Sloman, to your knowledge, are any of your letters appealable decisions under the Issaquah Municipal Code?
That's not my understanding of what is an appealable. It's not a decision, so that it is not appealable.
Okay. Has IHIFC attempted to appeal staff letters before?
Yes.
Could you describe that, please?
I believe that the April 4th, 2018 letter that Mr. Niven issued was appealed, and I believe there may have been another letter that was also appealed.
Do you know the outcome of the administrative appeal filed by IHIFC of the April 4th, 2018 letter?
That the hearing examiner denied that appeal.
Okay. Do you recall another appeal by IHIFC of the September 2018 staff reports prepared by staff in relation to this hearing?
Yes.
And what was the disposition of that administrative appeal?
That was also denied because a decision hadn't been issued.
So in both of those situations that you just testified to, IHIFC attempted to appeal writings by city staff that were ultimately found unappealable by the hearing examiner, if I understand
That's my
correctly.
understanding. I have not read those decisions in any detail.
Okay. Did that history factor into your decision to include this bolded language at the end of your April 15th, 2019 letter?
Yes, because I think we were concerned that this might be construed the same way, and since we had had those two decisions by the hearing examiner, we thought that this language was consistent with that.
Okay. Did you feel that that language was necessary in order to prevent IHIFC from filing yet another appeal?
Well, I don't know that they're welcome to file an appeal to anything that they choose to file an appeal on. I think we wanted to, based on the hearing examiner's previous decisions, communicate that we felt that this fell into the same categories as previous decisions.
Thank you. And when you say the same category, do you mean a category of non-appealable writings?
Yes.
Thank you. Could I turn your attention to Exhibit C59, the multicolored chart that was introduced into evidence at the previous hearing?
Oh, I'm sorry, I'm in the S notebook. Okay.
Believe that you testified that this didn't include a reference to the polygon short plat. Is that correct?
Yes.
And could you again explain why not?
Well, I don't think we were saying this was the complete universe of every permit that had been received. I think while it is true that Shelter had testified, their witnesses had testified about the short plat, we felt that the permits on this chart would reflect the larger land use permits, and that smaller permits such as short plats, lot line adjustments, et cetera, were not germane to what we were trying to represent.
Okay, thank you. I'm going to distribute a new exhibit. And this will be, I believe, numbered Exhibit C65. Ms. Fulman, can you please describe this document?
This document is a sampling of permits where the building permit was submitted and either routed or deemed complete, and by routing, that means it's been deemed complete prior to the approval date of the land use permit.
Did you create this document?
I did,
When did you create
using information from, not just my information.
When did you create this document?
Today.
Okay. And do you recall the questioning from Mr. Schneider and your answers concerning the Vale project and the interplay, if any, between the commercial project submittal checklist, as we've been referring to as the web document, and the city's willingness or ability to accept a building permit application before a land use notice of appeal has been issued?
I recall that conversation.
With that in mind, could you please explain the content of the new exhibit that I just handed you?
Sure. You know, at the time that I testified last time, Vale was the one that had come to mind. Mr. Snyder had questioned the whether it really illustrated what we thought it illustrated. I mentioned the Sunset Way duplex project, which at the time I did not remember the name of. So subsequent to our last meeting, I spoke with several staff, longtime planners in development services, because there is no easy way to find these permits. They're not tagged in any way. There's no way to search our permit database. So we had to rely on staff's memory of permits that might be illustrative of building permits being submitted and routed prior to land use permit approval. And so using the information that these various staff provided me, I then went into our permit database to confirm the permit numbers, the submittal dates or approval dates or routing dates as shown here.
So just to clarify, Ms. Sloman, the permit numbers and routing identification information and the other identifiers in the chart that we're discussing were actually verified by you personally?
Yes.
Okay. Is this an exhaustive list of projects for which a building permit application was allowed to be submitted without the requirement for a notice of decision for a corollary land use permit?
I can't say. I guess the two things I can say is it's not that common an occurrence because most applicants don't want to risk, as Ms. Heim identified, the expense of preparing a building permit without the confidence of the land use permit approval. However, they are able to do so, and some choose to go ahead and do it. And the Sunset Duplex is one in which they were submitted very close together. The other thing is, as I mentioned, that these are not tagged in any way, so we have to rely on staff's memory of permits, and so we had to go searching to try and find them. There's no easy way to pull them up.
But you, just to clarify, you did personally search and you did personally verify that information, correct?
So I was given a list by various staff members, and based on that list, then I went in and looked at each of these permits to confirm the land use permit number, the type, the approval date, the building permit number, the submittal date, and actually I was not provided with the routing information, so I had to go into our permit tracking program to identify that routing date.
Thank you. Do you recall your testimony in response to Mr. Schneider's questioning concerning the public access and utilities easement shown on the shelter property?
Mm-hmm.
Could you please describe that again?
The permit, the pedestrian or public access easement?
I had it written down as the public access and utilities easement. But
You're
I could be
right. That is what
mischaracterizing
the notation was on the drawing that we referenced.
Could you again describe that easement and its origins, how it came to be?
I don't actually know. I assume, as Mr. Snyder indicated, that it was a result of the work that Polygon was doing on their property. But who instigated that conversation with Shelter, how that unfolded, I don't have any direct knowledge of.
Do you know if Polygon ever objected to that?
Not that I'm aware of.
Has Shelter objected to that?
Not that I'm aware of.
Do you remember your testimony this evening concerning the December 15th, 2017 supplemental submittal that IHIFC filed in relation to its plat application?
Yes?
Okay. Do you remember this characterization of that document by Mr. Schneider in his questioning as being, quote, detailed and thorough, quote?
Yes, I remember him saying that.
Is that an accurate characterization?
It's very detailed. It is the information that was provided in the August submittal, while it may not have all been correct or answered every question, was sufficient for us to have processed a plat. We did not need the additional information that was added to the December submittal to be able to process the plat.
Did you request that information, or did the city request that information?
Not that I'm aware of.
And the submittal in December of 2017 of this document occurred when in relation to the build-out period under the development agreement?
It occurred after the build-out period,
Approximately how long after?
3 months.
Thank you. Could you please turn your attention now to Exhibit S65?
Okay.
Okay. And could you again describe that document once more for the record, please?
Sorry, still trying to wrestle the pages. So this email, I sent this email to Jean Lynn about a month or 5 weeks, maybe, after the notice of applications went out for 3 different permits. She did the notice of a combined notice of application on 3 permits. And I was complimenting her because I knew that she was doing work for more than just her own projects, and she had provided an overview map and some other things like that.
So let's explore that for a minute. When you were complimenting Ms. Lynn through your great job or good job email message, what did you intend to convey by that?
Well, that she was doing work for other staff, such as myself. She was, she had prepared, I believe that she was the one who prepared the map showing how the 3 pieces related to each other, which I believe was also included. And that the textual part of the notice of application that she had done, I thought was a good representation of what was happening with that permit.
I believe that you testified in response to applicant counsel's questions that you had not personally reviewed Shelter's December 15th, 2017 supplemental submittal before you sent that email to Ms. Lynn. Is that correct?
Right. I'm not sure when I became aware of that submittal. It's very likely that I was unaware of it even at this time in February.
So just to clarify, if I understand your testimony, Ms. Sloman, your congratulatory email to Ms. Lynn had nothing to do with the substance of the notice of application?
Well, I'm not sure I would agree with that. I think it had to do potentially with the substance of the textual part, the front of the notice of application. I don't know where that exhibit is, but the front is all the words that describe the project and the interplay and of different permits, and I thought that she had done a good job using that form. It may have been the first time she sent out a notice of application, given that she'd only worked for the city about 6 months. I did not focus on the maps. That was taking a map and attaching it to all the textual description, and I think I was focused on the textual part of it.
There's been a lot of testimony about whether and to what extent the city informed IHIFC that pre-application conference was required. Do you recall that, or a pre-application submittal?
Yes,
And do you recall your own questioning and answers on that point?
I believe so.
Okay. For clarification, did the city originally tell IHIFC that a pre-app was required?
Yes.
Okay. Do you know approximately when that statement would have occurred?
Well, Ms. Heim originally, I believe the emails that I found where she questioned our requirement was that took place in October, end of October 2017.
Okay. And is it your testimony, Ms. Sloman, that that statement was retracted by the city?
Yes, because while there's Director Niven's November 1st email, which we've read and which has two different kinds of statements in it. There's Ms. Heim's testimony, as I recall it, saying that it was November 6th. But at the time when I issued the sufficiency or insufficiency letter on the first two site development permits that Shelter had submitted, I did not identify that the pre-app meetings had not taken place. And I am very confident that I would not have unilaterally made that decision, or that I would not have included it if I was not, if I felt that that was an outstanding item.
Do you say that with certainty?
Yes.
I'm sorry?
Yes.
Okay. And what was the date of that letter? Or those
December
letters?
1st.
Okay. Could you turn to Exhibit C50? I believe this was the email from Mr. Niven that you were referring to, but I'm going to verify that.
Sorry, which exhibit?
Exhibit C50?
I'm at C50.
C50, yes.
I'm there.
Thank you. Was this the email message that you were referring to?
Yes.
Okay.
Yes.
I'd like to direct your attention to the second paragraph of that email message from Mr. Niven to Ms. Heim, with you as a courtesy copy recipient, along with various other people. And the text that reads, "Your first point is that the pre-application meetings are listed in the agreement as, quote, optional. This is true." Parentheses, Appendix L, page L4, end paren. Do you see that language?
I do.
And then could you please look at the fourth paragraph, beginning with the text, "Under existing city processing,
Yes.
the pre-application meeting is not optional. It is a required part of the process." Ms. Sloman, how do you construe the reference to existing city processing in that statement? What is that a reference to to your knowledge? Is that the city's code, or is that something else?
Well, I think that it's difficult for me to speak to this because I didn't write it. I think it was common practice that we had a pre-app meeting, at least in certain parts of the city, and that we found that necessary and useful. I don't know exactly what Director Niven meant specifically by this text, but I guess that's what I take away from it.
Do you understand what you're saying about not being able to read Mr. Niven's mind, but do you construe the first reference, the reference that I had you look at in the second paragraph, as Mr. Niven retracting the city's previous statement that a pre-application was required?
Well, it certainly seems to acknowledge what the development agreement says.
Thank you. And then finally, with respect to your relationship with the editor of the Connections publication, do you recall your testimony on that point?
Yes.
Could you please again describe what relationship you have with that individual?
It's collegial. She's very interested in planning. She and I had worked together professionally over the years when she was on the Urban Village Development Commission, when she was on the council, and we enjoyed many of the same interests and found those conversations helpful in discussing various issues. We didn't always agree, but they were enlightening.
Thank you. My final question is, have you been present for all of these proceedings?
Yes.
Did you listen to Mr. Niven's testimony in the September and/or October hearings concerning his interpretation of the development agreement regarding vesting?
Yes.
Do you agree or disagree with Mr. Niven's testimony?
Well, I can't say I remember exactly what he said at that time. I don't know that I can, I don't remember thinking, what? So I assume that I agreed with it, but I don't recall specifically what he was testifying to.
Thank you. No further questions?
Well, the timing is good. Mr. Snyder, do you have a lot of comments to make?
I would say I probably, just on the new stuff that was introduced, the new exhibits, and I probably have 15 minutes across. I would suggest we do it next time. And in light of how long things took tonight, I no longer feel confident we're going to get done next time. I think we all desperately want to, but I'm not confident it's going to happen. So I would request, as a, in case it's needed, that we schedule one more hearing, so two more. The one that I understand scheduled for the 30th, and then one more after that, just in case we need it.
Okay, so, Mr. Lell, does that timeline seem to be consistent with what your interests are?
It is. I think it's an accurate, or at least a realistic estimate of what will be necessary given the history here. I don't know how many rebuttal witnesses that the applicant intends to call. My recollection is that it was in the neighborhood of 3 to 5.
I think we're at 3. 3, but then there'll be your costs, so.
I would agree with Mr. Snyder that out of an abundance of caution, scheduling an additional hearing date makes sense.
Excuse me, we have 4 rebuttal witnesses. So I think we need to schedule a second hearing.
So we have reached the time to adjourn, and we'll be continuing the public hearing on tonight's agenda to a future date. And my understanding is that the commission is next available to continue on May 30th. That's correct, and we will be searching for another meeting after May 30th to continue. Does that sound correct? We'll reconvene on May 30th to complete the testimony and may probably go to another meeting to begin our deliberations. So let's consider ourselves adjourned.
Thank you.
Thank you.